So the first area we're going to examine is the extent to which English defamation law imposes liability without fault. So according to common law, anybody who distributes defamatory information can be held liable, even if they're all like proximity towards the final defamatory act. For example, a newspaper retailer who sells a newspaper that has a defamatory article in it can be held liable for defamation. And it's irrelevant whether the defendant was at fault or not for damaging the claimant's reputation, as long as the publishing has damaged the reputation. This can create injustices, however, in cases where a defendant innocently and perfectly reasonably said something that had the effect of making the claimant look bad. There is a defence in Section 1 of the Defamation Act 1996, which says that where the defendant can show that he was not the author, editor or publisher of a defamatory statement, or he took reasonable care in relation to the publication and did not know that his actions had contributed to the publication of the defamatory statement, he can't be held liable. This was explored in two cases. Firstly, in Godfrey versus Demon Internet, where the defendant was found liable for allowing defamatory information to remain on his website despite the claimant requesting that the information be taken down. It was held that since the defendant had the power to remove the information, because he was the host of the website, he was responsible for the control, and because he had the control, he was liable. This contrasts Metropolitan International Schools versus Design Technica Corporation, in which the defendant was held not liable under similar circumstances because this time the role and power of the control of the post on the website was much lower than that of the defendant in Godfrey.
Okay, we've been asked a question whether it should be reformed as to show fault, and we think it would make sense, as was explained in the New York Times versus Sullivan case. It would make sense if the party had deliberately showed malice to defame somebody. That would be a more plausible scope for liability within defamation, because it would show exactly who is responsible for it. And because at the moment the current law seems to be very wide in terms of defining liability, and it seems that somebody with such a small connection with a defamatory statement could be held liable for its publication. Two main areas that this large scope falls under would be the multiple publication rule and the repetition rule. The repetition rule became particularly apparent in a case, McManus versus Beckham, where Victoria Beckham made a statement in a shop that the stuff that her husband had signed were fakes, and people then repeated that, and it was held that the people that relayed Victoria Beckham's defamatory statement could have been held liable. I think that it should only be the first person that is held liable. If they are to be held liable, it should only be the first person that says the statement, and because the responsibility should remain with the original tortfeasor, because as in the McManus case, it seemed it was reasonable to assume that what Victoria Beckham was saying was the truth. And also another point to moving on to the multiple publication rule. This was raised in the case Slipper versus BBC, and the rationale of the case was that the maker of a statement could be held liable for republications by others. It was held that the multiple publication rule follows the same rules as the novus actus interveniens. This somewhat creates an issue of proximity. Should the original defendant be held liable for third parties? Personally, I don't think so, but this is a question that has to be redressed due to the rise of internet becoming a medium for the media to express themselves. The government has sought to redress this through Clause 6 of the proposed defamation bill, which is proposed to get rid of the multiple publication rule in favour of single publication rule, under which the claimant has 1 year to sue in defamation from the date of the first publication. And this gives some much needed protection to publishers, as they should only be held liable for the original statement that was made.
Okay. Finally, we were thinking about whether it makes sense to have stricter liability for defamation rather than personal injury. And it does make sense to have stricter liability for defamation because both are serious claims, but there's more at risk for a claimant in defamation cases. A person's reputation can be destroyed through a false claim. And this can cause greater difficulty overall for defendants because entire lives can be destroyed, whereas, say, in personal injury, it might just be like a claim for damage to a car or something very, very minor, and in the grand scheme of things, quite insignificant. At the same time, in personal injury cases, there's some harm done, but nothing so serious that it can make such a drastic change to how somebody's life can be lived. Having stricter liability for defamation than for personal injury is rational on a matter of principle because, as the other group talked about, freedom of the press and the Human Rights Act, it's a deterrent and retributive measure because it regulates the power of free speech and the right to free speech. And personal injuries are largely compensatory, and it focuses on aiding the wrong individual. But if you focus it on the regulatory idea, you can have less cases like what's been happening with the Levinson inquiry recently and the injunction scandal that happened over the summer last year, where they were questioning whether they should take Twitter to court over things that have been repeated. And it just makes more sense to kind of control the entire area. The claimants in defamation cases are generally wealthy as well. That could mean that, they're targets or something, but it's questionable whether it seems fair that they can receive more compensation than the average personal injury claimant as well, because in those cases they're more high profile, and like I said before, there's more at stake. Personal injury compensation is sometimes given as a particular injury has made the claimant unable to work, whereas the defamatory statement has led to employers not wanting the claimant. And it's also should be questioned whether appropriation of damages should be more equal. So both areas should be kind of controlled as well.
Excellent, really good job, well done.